Law of contract, nature and kind. The Indian Contract Act, 1872 prescribes law relating to contracts in India. Section S.2 H of the Indian Contract Act defines contract as an agreement enforceable by law. The law of contract can be divided into following types, namely: 1. Void agreement. 2. Voidable contract. 3. Void contract. 4. Unenforceable contract. 5. Illegal or unlawful agreement. 6. Express and implied contracts. 7. Executed and executory contracts. 8. Unilateral and bilateral contracts. 9. Formal and simple contracts. Let us understand various types of contract one by one. The first type of contract is void agreement. Section 2G of the Indian Contract Act states that an agreement not enforceable by law is said to be void. A void agreement does not give rise to any legal consequences. It is void ab initio, that is void from the very beginning. For example, an agreement with a minor is void, or an agreement without consideration is void. Indian Contract Act defines voidable contract as an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others. For example, if X is forced to sign a contract, the contract is voidable at the option of X. X may either rescind, avoid or repudiate the contract or elect to be bound by it. A voidable contract continues to be good until it is avoided by the party entitled to do so. The various circumstances in which a contract is voidable are depicted by the following chart. The third kind of contract is void contract. Section 2J of Indian Contract Act defines void contract as a contract which ceases to be enforceable by law, becomes void when it ceases to be enforceable. For example, a contract between drug dealers and buyers is a void contract simply because the terms of the contract are illegal. Difference between void and voidable contracts. 1. Void contracts. A void contract is one which is valid when it is made but becomes void at a later stage. Voidable contracts. A voidable contract is one which is enforceable by law at the option of one of the parties. 2. A void contract cannot be enforced. Whereas, a voidable contract can be enforced if the aggrieved party elects to carry out the contract. 3. Void contract. A contract becomes void due to certain reasons like impossibility of performance, subsequent illegality, etc. Voidable contract. A contract becomes voidable if consent is caused by coercion, undue influence, fraud and misrepresentation, or failure to perform at the time fixed if time is essence of the contract. Last but not the least. 4. Under a void contract, compensation is not payable except only when party knows beforehand about the impossibility of the performance. Whereas, in a voidable contract the aggrieved party can claim damages. The next type of contract is unenforceable contracts. An unenforceable contract is one which suffers from some technical defect such as lack of attestation, registration or affixing of certain amount of stamps, etc. Example: 1. Non-registration. 2. Want of proper stamp. 3. Lack of signature. Another type of contracts are illegal or unlawful contracts. According to Section 23 of the Contract Act, an agreement is illegal and void if its object or consideration is 1. Forbidden by law. 2. Is of such nature that it would defeat the provisions of any law, or 3. Is fraudulent, or 4. Involves or implies injury to the person or property of another, or 5. The court regards it as immoral or opposed to public policy. express or implied contract. Section 9 of the Act says that when the proposal or acceptance is made in words, written or spoken, the promise is said to be express. An implied contract is created by the conduct of the parties or is inferred from circumstances. For example, A steps into a bus to go to a certain location. A is bound to pay the fare, although he has not in words promised to do so. The next type of contract is executed and executory contract. An executed contract is one that has been performed by all parties. For example, A buys a TV set from B for Rs. 20,000. A pays the price and B delivers the TV. It is an executed contract. An executory contract is one where both the parties have still to perform their respective contractual obligations. For example, A contracts to sell and deliver a TV to B for Rs. 20,000 to be paid in 3 weeks. A delivers the TV. The contract is executed as to A, executory as to B, as B has not yet paid the agreed price. Unilateral and bilateral contract. In case of a unilateral contract, only one party has to perform its obligation and the other party has already performed its obligation at the time of formation of contract or before. A bilateral contract is one in which both the parties are yet to perform their respective obligations at the time of formation of contract. Last type of contracts are formal and simple contracts. This classification is made in the English law. A formal contract is expressed in a particular form. Its validity depends on form alone, that is, it is in writing and is to be signed, sealed and delivered by the parties. The signature is usually attested. Formal contract is divided into following 2 types. 1. Contract of record. 2. Contract under seal. Lastly, simple contract includes all contracts not under seal, and for their enforcement they require the fulfillment of the essential elements of the contract. That is consideration, free consent, etc. Simple contracts may be made or a law in writing. These are various kinds of contracts. Thank you.